everyone. This video talks about intellectual property right, which is one of the most important aspects in business. And the strange thing is that most of the people are not completely aware about them. So, this video will help you to learn about them. Now, if you can't spot the mistake in the given picture, then you are the one who definitely needs to go through the video. So, here we begin. Now, the first question that comes in our mind is, what is intellectual property? In simpler words, intellectual property is creations of mind such as inventions, literary work, symbols, names, images, etc. It is a category of property that includes intangible creations of the human intellect. Intellectual property encompasses two types of rights. First is copyright. The rights of authors of literary and artistic works such as books and other writings, musical compositions, paintings, sculpture, and computer programs are protected by copyright. The main social purpose of protection of copyright and related rights is to encourage and reward creative work. The second category is industrial property. Industrial property can be usefully divided into two main areas. One area can be characterized as the protection of distinctive signs, in particular geographical indications. Other types of industrial property that are protected are primarily industrial designs and trade secrets. We will be talking about these rights, what they are, how they are protected, their infringement, and other aspects related to them. Before we move ahead, we need to look at why we need IPR. First is to avoid the problem of free riding. A free rider is a person who benefits from something without expending efforts or paying for it. The free rider problem found in intellectual property protection is that owners of patents believe that their patents provide them absolute rights. This can create a free rider problem. Many patent owners free ride on resources, goods, or services for which they have not paid. Next one up is financial leverage. IPR gives new ways to financially leverage the intellectual property through licensing opportunities. Next is to avoid plagiarism. It is the practice of taking someone else's work or ideas and passing them off as one's own. So, IPR offers a protection against this so that nobody else can take credit for your work. Next is company value. Know how, technology, copyright, trademark, innovation, and reputation are some of the intellectual property rights. They comprise the bulk of the value of a business rather than the buildings, desks, cabinets, and machinery. That is very clear. These resources of a business are the building blocks of brand value. So, a good intellectual property management system adds to the value of a company. Next is avoid infringing. IPR provision recognizes infringement as an offense and it offers numerous remedies against infringement of these IPR such as injunction, compensation, etc. Next is avoid counterfeiting. Counterfeiting is a fraudulent imitation of something else. Here, something else is intellectual property such as a book, song, product, etc. The counterfeit market has become more and more professional. Sometimes counterfeit goods appear on the market before the authentic products themselves. The loss of revenues from counterfeiting is estimated at hundreds of billions of euro worldwide. Counterfeiting and piracy have especially negative impact on innovation and investment. Therefore, protection against counterfeiting is a must for any organization. Having understood the need of IPR, now we will move ahead to understand how the concept of IPR came into being. TRIPS was negotiated at the end of Uruguay round of the General Agreement on Tariffs and Trade between 1989 and 1990 and is administered by the WTO. It came into effect on 1 January 1995. All the WTO member countries are the parties to this agreement, and the basic purpose is the protection of IPR. The agreement sets out the minimum standards of regulation found by signatories that each member country must fulfill. It is an effort to bring national legislations under common international rules. Member countries have to prepare necessary legal framework according to these standards of protection. Covers 8 areas for IPR's legislation such as patent, copyright, geographical indication, etc. It also specifies enforcement procedures, remedies, and dispute resolution procedures. So, this was all about TRIPS. Now, we will see how IPR are protected in India. Now, these are some of the rules and laws governing intellectual property rights in India. Just have a quick look at them. You can see that the first law related to IPR came in the form of the Copyright Act, that is in the year 1957. Then the Patents Act, Trademarks Act, the GI Act, Semiconductor Integrated Circuits Layout Design Act, IT Act, and finally the latest one to come up is the Patent Acts 1970 as amended in 2005. I am sure you must have got a fair idea about the laws that operate in India for the protection of IPR. So now we will look at the various types of IPR one by one. So we begin with trademarks. Trademark is a logo or combination of characters and numerals used by a company to claim its ownership on a term or design to represent its products and services. There are various types of trademarks which can be registered, like product mark, service mark, collective mark, certification mark, shape mark, sound mark, and pattern mark. Though there are many kinds of trademarks, their purpose is for the same, which is to enable the consumers identify goods and services originating from a certain manufacturer or services provider. Trademark registration is a lengthy process and it takes around 18 to 24 months to obtain registration in a straightforward case without any objections or oppositions. However, the trademark application number is usually issued within 1 or 2 days after filing. Once the trademark is registered, it is valid for a period of 10 years from the date of application. The registration can then be renewed indefinitely as long as the renewal fees are paid every 10 years. The infringement of trademark is violation of exclusive rights that are attached to a registered trademark without the permission of the registered owner or licensees. Depending on how extensively a trademark was violated, trademark infringement penalties can vary from case to case. The most common penalty for trademark infringement is an injunction or a cease and desist letter directing the infringer to stop using the trademark material. The court may also award monetary damages. So, this was all about trademark. Next one on the line is patent. A patent is an exclusive right granted for an invention. In other words, a patent is an exclusive right to a product or a process that generally provides a new way of doing something or offers a new technical solution to a problem. The invention must meet three conditions to be applicable to be patent. It must show an element of novelty, that is, some new characteristics which is not known in the body of existing knowledge in its technical field. Second is the invention must involve an inventive step, which means that it could not be obviously deduced by a person having ordinary skills in the relevant technical field. The invention must be capable of industrial application, meaning that it must be capable of being used for an industrial or business purpose beyond a mere theoretical phenomena. For the registration of a patent in India, the specified form duly completed along with requisite government fees have to be submitted before the Patent Office, Government of India. The term for patent in India is valid for 20 years, and granted patent remains active in the register maintained by the Indian Patent Office only by paying the renewal fees from time to time. Patent infringement occurs when another party makes, uses, or sells a patented item without the permission of the patent holder. When a court finds infringement, the infringer usually must pay damages to the patent holder, either in the form of actual damages or a reasonable royalty for the unauthorized use. In addition to infringement damages, a patent owner may stop the infringer from continuing to produce the infringing products. So this was all about patents. Now we will talk about GI, shortly known as geographical indications. A geographical indication is a name or sign used on product which corresponds to a specific geographical location or origin. The condition to be met is that the product must have a special characteristics which is present due to its geographical location. A single unique characteristics linked to its geographical origin is sufficient, be it a quality or other characteristics of the product or only its reputation. The examples of GI in India are Darjeeling tea, which became the first GI tagged product in India. Other examples are Madhubani paintings, Bhagalpur silk, sticky grass work of Bihar. An application for registration must be made before the Registrar of Geographical Indications by any association of persons or producers or any organization. A GI is registered for an initial period of 10 years, which may be renewed from time to time. A person who is not an authorized user of a registered GI infringes it when he uses the GI in such a way that it shows that the product is originating from other place other than the true place of origin of that good. The second case in which infringement of GI takes place is when a person uses any GI in such a manner which constitutes an act of unfair competition. The remedies available for protection of GI may broadly be classified in two categories. First is civil remedies. The Act provides for the following civil remedies for infringement of a registered GI. First, injunction. Second, damages or account of profits. Third, delivery up of the infringing labels and indications. The second one is the criminal remedies, which may be imprisonment or a fine, or imprisonment and fine together. Having learnt about geographical indications, now we will move ahead to learn about copyrights. Copyright refers to the legal right of the owner of intellectual property. In simpler terms, copyright is the right to copy. This means that the original creator of a product and anyone he gives authorization to are the only ones with the exclusive right to reproduce the work. Under certain conditions, copying is permitted without specific permission of the copyright owners. Some of the exemptions are for the purpose of research or private study, for criticism or review, for reporting current events in connection with judicial proceeding, and a few more. Copyright comes into existence as soon as a work is created, and no formality is required to be completed for acquiring copyright. However, facilities exist for having the work registered in the Register of Copyrights maintained in the Copyright Office of the Department of Education. The copyright protection varies from country to country. In India, the general rule is that copyright lasts for 60 years. In the case of original literary, dramatic, musical, and artistic works, the 60-year period is counted from the year following the death of the author. In case of cinematograph films, sound recordings, photographs, posthumous publications, the 60-year period is counted from the date of publication. Now, when a person intentionally or unintentionally copies or uses the work of another creator without his prior consent or permission, it amounts to infringement of copyrights. A copyright owner can take legal action against any person who infringes the copyright in the work. The copyright owner is entitled to remedies by ways of injunctions, damages, and accounts. Now, the last one to be discussed here is trade secrets. A trade secret is a formula, practice, process, design, instrument, pattern, commercial method, or compilation of information which is not generally known to the public and by which a business can obtain an economic advantage over its competitors. The owner of the trade secret generally intends to keep that information hidden and confidential. Trade secrets are protected without any registration. That is, trade secrets are protected without any procedural formalities. India does not have a specific codified legislation to protect trade secrets. Due to the absence of law for the protection of trade secrets, the Indian courts relies on the common law remedies for the protection. A common way to protect trade secrets is signing non-disclosure agreement which binds the parties not to leak information or else they will face legal action. An employee is often made to sign such an agreement before he joins an organization. In case of protection of trade secrets, the onus solely lies on the individual to keep the information safe. Or in case of infringement of a trade secret, the Indian courts provide common remedies such as injunction, pay for damages or compensation if the leaking of trade secrets has caused any loss to the organization. So, this was all about trade secrets. With this, I would like to end this video here. Hope the video gave you adequate information about the IPRs.